We will be advising Rosewood on whether they are able to recover the Italian furniture from Pine Furnitures. This dispute was between two innocent parties because Rosewood is induced to sell the Italian furniture to Timber Crook on credit in the belief that they are Timber Creek. Before Timber Crook had paid for the furniture, he sold them to Pine Furnitures. When Rosewood discovered that Italian furniture were now in the possession of Pine Furnitures, they may bring an action in conversion against Pine Furnitures. The outcome of this claim will decide whether Rosewood or Pine Furniture has the better title to the furniture. To determine whether Rosewood may be able to recover the Italian furniture from Pine Furnitures under English law, we will need to look into the first contract between Rosewood and Timber Crook. The first issue we'll be looking at is what are the vitiating factors present in the contract between Rosewood and Timber Crook. On the facts of this case, it seems that Rosewood can bring an action against Crook on the possible grounds of fraudulent misrepresentation or mistake. It can be argued that Rosewood made a mistake as to the identity of the other party. David, as the authorized sales manager of Rosewood, was mistaken about the identity of the other party. Thus, Rosewood cannot be said to be consenting to the contract because there was no consensus ad idem between Rosewood and Timber Crook. Fraudulent misrepresentation is also another possible vitiating factor here. Thomas Crook signed Thomas Creek on the order even though he wasn't Thomas Creek. Thus, Rosewood's mistake was induced by the fraudulent misrepresentation of Thomas Crook. Hence, it would be more beneficial for Rosewood to bring cause of action against Timber Crook on the grounds of unilateral mistake as to identity, as Rosewood will have a chance to claim back the furniture. However, we will examine whether it is actually possible to bring this cause of action in detail later. The second issue is whether the contract between Rosewood and Timber Crook is in the absentis or in the presentis. The contract between Rosewood and Timber Crook is in the absentis because they are not in each other's physical presence from the time the misrepresentation as to identity is made until the contract is concluded, with Rosewood believing that they are contracting with Timber Creek. Courts will seem more ready to find the contracts in the absentis void for unilateral mistake only when Timber Creek is an existing company. The leading case on this subject is Shogun Finance and Hudson. The majority decision of the House of Lords in this case are, if the contract between the seller and the intermediate buyer is made in the absentis, the rebuttable presumption is that the contract between A and B is void for mistake, and C cannot pass title to D. The difference of whether the claimant intends to contract with some existing and identifiable person other than the one with whom he has made the contract can be seen in the case of Candy and Lindsay, and in the case of King's Northern Metal Company and Attridge Marine and Company Limited. In the former, the contract is held to be void because the claimant's offer was to a reputable firm and the defendant could not accept it by misrepresenting his identity as the reputable firm. The defendant therefore did not obtain the title of the goods and could not pass the title to a third party. The claimant could therefore recover the goods from the third party. Whereas in the latter, the contract between the claimant and defendant is not void but voidable due to the fact that the defendant misrepresented himself as a company which did not exist. Hence, even though the contract is voidable for fraudulent misrepresentation, the claimant could not recover the goods from the third party. There is also the issue that there was no business operating at Timber Crook given address. Whether or not Timber Crook existed is not important in this case, it is a mere red herring. The right question is whether Timber Creek existed. According to King's Northern case, the Court of Appeal stated that if Harlem and Company, the company which the fraudulent party misrepresented themselves as, was real, then it might have been void for mistake like in Candy and Lindsay. So, it's clear that we'd have to determine the existence of the company whose identity was stolen, which is Timber Creek, not the party which committed the fraud misrepresentation, which is Timber Crook.
Now, I will address the next issue of whether the contract between Rosewood and Timber Crook is void for operative unilateral mistake or merely voidable for fraudulent misrepresentation. A void contract is one that is declared to be a nullity and is treated as if it was never formed at the beginning, also known as void ab initio. Therefore, if the contract between Rosewood and Timber Crook is void, the title for the Italian furniture will not be passed from Rosewood to Timber Crook, meaning Rosewood can recover the furniture. And on the other hand, a voidable contract will remain as a valid and enforceable contract until and unless it is rescinded by Rosewood, meaning Rosewood will not be able to recover the Italian furniture. This is because in the common law, the general rule is that only the owner of the goods could pass lawful ownership or title of goods to the buyer. This is consistent with the rule of nemo dat quod non habet. This common rule that was originally set out in Section 21 of the Sale of Goods Act 1979 and is also applied in numerous cases such as in Kandi and Lindsay, where it was held that no good title can be passed from the seller to the buyer when a contract is void. Therefore, if the contract between Rosewood and Timbercrook is void ab initio, no title of the furniture will be passed to Timbercrook nor to Pine Furniture, thus allowing the rightful owner, which is Rosewood, to recover the Italian furniture. Hence, based on what Jacelyn and I have addressed, in order for Rosewood to recover the Italian furniture, they have to claim that the contract with Timbercrook is void ab initio due to operative unilateral mistake. To establish this, there are 4 elements that Rosewood must prove. Firstly, Rosewood has to show that they intended to contract with Timbercrook instead of Timbercrook. To prove this requirement, there has to be a fundamental mistake as to the identity of the party whom Rosewood was selling the Italian furniture to. And based on the facts of the present case, there was a confusion on whether the company that Rosewood was contracting with was Timbercrook or Timbercrook. So Crook had represented himself as Creek by signing Thomas Creek on the fax order. Hence, Rosewood was led to believe that they were contracting with Timbercrook. Thus, Rosewood can prove that they intended to contract with Creek by showing that there was confusion between these 2 distinct identities. Secondly, Rosewood must prove that Timbercrook knew of Rosewood's intention to contract with Timbercrook. This element is fulfilled because it is clear that Thomas Crook from Timbercrook had a motive to misrepresent himself as the managing director of Timbercrook to Rosewood. This can be seen when 1. The fax order received by Rosewood appeared to be of Timbercrook's letterhead, when in fact it was actually headed to Timbercrook. This means that Timbercrook designed their letterhead to look similar to Timbercrook's, with the exception of the name of the company on the fax order. The signature, on the other hand, also appeared to be signed by Thomas Crook, which was aimed to induce Rosewood to believe that they are contracting with Timbercrook for the Italian furniture. 2. Thomas Crook signed the delivery order as Thomas Crook. So based on these 2 actions, we can conclude that Timbercrook was aware of the intention of Rosewood to contract with Timbercrook due to their creditworthiness, and therefore planned to misrepresent their identity as Timbercrook to induce the contract between them. Thirdly, Rosewood must prove that the identity of the person they have contracted with was of importance to them. So in other words, we need to consider whether the identity of the person in the fax order is of significant importance to Rosewood. The court held, in the case of Kandi and Lindsay, that the contract is void between the parties as the identity of the purchaser was of importance, and that claimants intended to deal with that particular purchaser and not anyone else. Besides, in the present case, we also have to consider the characteristics of the company of Rosewood. So Rosewood is a supplier of expensive furniture to retailers, and therefore they may be more tedious and more attentive towards who they will be supplying their goods to. This can be seen from the full investigation carried out on Timbercrook. Thus, it can be proven that Rosewood only wanted to contract with those whose credibility have been confirmed. In addition, this is a contract made inter absentis. We can therefore conclude that the identity of the person contracting with Rosewood is of significant importance. Lastly, Rosewood must prove that they have taken reasonable steps to check the identity of the person they contracted with. This element might not be able to be proven because Rosewood did not take reasonable steps to verify the identity of Thomas Crook and Timbercrook. There are few reasonable steps that should have been taken by Rosewood, and doing so will lead them to discover that the fax order was actually not faxed by Timbercrook. Firstly, Rosewood should verify whether the fax number used to send the fax order is the same as given in the calling card given by Thomas Crook. Moreover, if Rosewood read the fax order properly, they will find that the order was actually headed to Timbercrook instead of Timbercrook. As Rosewood only fulfilled 3 out of the 4 elements, the contract between Rosewood and Timbercrook is not void for mistake, but merely voidable for misrepresentation due to the lack of reasonable steps to verify the identity of the other party.
Under the English law position, our conclusion for the advice for Rosewood is that Rosewood does not fulfill all the elements to prove that the contract between Rosewood and Timbercrook is void for operative unilateral mistake. As proven in the previous arguments, the first contract is valid and Rosewood could not recover the Italian furniture from Pine Furnitures, the innocent third party who is a bona fide purchaser not aware of the fraudulent misrepresentation. Nonetheless, since Rosewood's mistake was induced by the fraudulent misrepresentation, the contract will be voidable. Fraudulent misrepresentation gives the innocent party the right to bring an action in tort deceit.
And now I'll be discussing Italian furniture under Malaysian law. So in Malaysia, the law relating to unilateral mistake is provided under Section 23 of the Contracts Act. But it's ambiguous as it's unclear whether such an agreement is valid or void, as Section 23 does not render a contract voidable for unilateral mistake of fact. Thus, to clear this confusion, we will first need to consider the first issue, which is, Does Malaysian law render a contract void for unilateral mistake? Now, prima facie, Section 23 seems to indicate that even if there was a unilateral mistake, the contract will still be valid. And Alsagoff supports this literal interpretation of this on the grounds that Malaysian law protects the bona fide purchaser. He opined it is so unfair to penalize the innocent purchasers in favor of the contracting party who contracted under a mistake of identity, which may have very well been the result of their own carelessness. But on the other hand, Feng Ming argues that it appears that the framer intended to have this provision to be left in an open-ended manner, as this allows the judges to decide the effect of such mistakes depending on the circumstances of each case. The authors also viewed that this is in line with the principles in modern contract law, which encompasses the concept of pragmatism, which is basically promoting contractual fairness and providing protection to the weaker party. So we can see that it's a shift in judicial role from principles to pragmatism. We have also found Malaysian cases such as Tham Kong against Oh Hiam and Crescent Concrete against Sulong Engineering, where they affirm the view where the mistake of one party will not prevent the formation of a contract. However, Sinudurai argues that Section 23 merely covers cases where the mistake is one that is not a matter of fact essential to the agreement. He further argues that if the unilateral mistake is with regards to the identity of a person or about the terms of a contract, then no binding contract occurred as there is no consensus ad idem between both parties. And this follows Section 13 of the Contracts Act. So it must be an operative unilateral mistake, in which case Malaysian courts should then be inclined to follow common law approach. Operative unilateral mistake can be categorized into A, mistake as to identity, and B, mistake as to terms. And in this case, we are focused on the former. We also agree with Sinudurai's argument because we have found 5 cases with dicta supporting this view. And the cases are Ann Pacquiam against YP Deva Tanjung, the Golf Track Book against Nilai Springs, Lim Li Tai against Koh Heng Jin, Andrew Reid against Henry Ong, as well as Menta Construction against Lestari Puchong. And all 5 cases espouse the notion that a unilateral mistake of fact regarding a fundamental matter could render a contract void, be it on grounds of Section 13 or on common law. Next, we move on to the second issue, where we ask ourselves, is this a case of unilateral mistake as to identity? So, we determine that a unilateral mistake of identity can render a contract void. But in order to establish whether Rosewood has a cause of action under mistake as to identity, Rosewood has to fulfill the 4 elements established in common law, since there are no clear Malaysian cases on this matter. And Justice Gopal Sri Ram, in the Golf Track Book case, has mentioned where the unilateral mistake is fundamental, Malaysian courts may be inclined to follow the common law approach. Earlier, Jacelyn has concluded that all the requirements were fulfilled except for the 4th one. Hence, unfortunately, Rosewood does not have a cause of action under mistake as to identity. Now, a side issue to note here is that it doesn't matter if it was a mistake as to identity or mere attributes. We argue that even though we follow common law principles, which differentiates those 2 elements and hence will lead to different results, Malaysian courts have not drawn a distinction between these 2 categories. Hence, it is logical to postulate that it's likely they wouldn't do so in this case too, as they would be following precedent. So basically, they would just be considering this a general unilateral mistake on a matter of fact essential to the agreement. And in fact, in English law, upon analysis, we concur that the stance might be changing, as in the case of Lewis and Avery, Lord Denning held that regardless whether it's a mistake of identity or attributes, both only render the contract voidable. Similarly, in Shogun Finance, Lord Miller in his dissenting judgment supports this abandonment of the distinction between mistake of identity and mistake of attributes. But we digress from discussing further. Let's move on to the third issue, which is the contract valid then? No, because the contract is voidable under fraudulent misrepresentation. Fraud is provided for under Section 17 of the Contracts Act, and it includes any acts that are specifically stated in its sub-provision A to E. We can follow the recent case of Sri Indran Ram, anak lelaki Ramasamy, against Wong Yu Ki, in which the plaintiff here claimed that the first defendant was liable in fraudulent misrepresentation in his representation to the plaintiff. And as a consequence of such misrepresentation, the plaintiff was wrongly induced into this agreement. And the court in this case held that the defendant was liable in fraudulent misrepresentation. So it's clear that if you follow this case, under Malaysian law, Rosewood's contract with Timbercrook would be found voidable for fraudulent misrepresentation, and Rosewood cannot claim their Italian furniture back.
The contract between Edgar representing Rosewood and the man identifying himself as Thomas Creek, who is physically present at the showroom to buy Korean furniture, is voidable. The parties concluded their agreement on the basis of a mistake that may vitiate the contract to the point of rendering it a nullity. The mistake was unilateral because there was a mistaken belief held by only one party and that belief was not shared to the other. The Malaysian law relating to unilateral mistake is provided in Section 23 of the Contracts Act, under the circumstances that if the contract is clear, a unilateral mistake will not affect the validity of a contract because the person is expected to take reasonable care to ascertain what he is contracting about. The Malaysian court will not allow a contract where there was no consensus ad idem, nor will they allow a non-mistaken party to take advantage of an error which he was or also have been aware of. There was no consensus ad idem in the contract between Edgar representing Rosewood and the man because it seems that there was a mistake as to the identity of the man. This mistake is a fact pertinent to the subject matter of the contract, therefore it can be seen as an exception that does not fall within the ambit of Section 23 of the Contracts Act by applying sine Durain's interpretation as mentioned earlier by my teammates. Although Section 23 of the Contracts Act does not directly render a contract voidable for a unilateral mistake of fact, the legal recourse for a mistake of identity is sufficiently provided in common law. Hence, by virtue of Section 3 of the Civil Law Act 1956, which enables the application of English common law in Malaysia, our Malaysian law position for this part of our assignment question will be the same as English law because the common law jurisprudence is the applicable law.
Now, I will explain on the applicable law. To begin with, we have established that this transaction between Rosewood and Thomas Crook, the fraudster, was made with not only a mistake on identity, but also comprising fraudulent misrepresentation. It is a fraudulent misrepresentation because Thomas Crook has made an unambiguous false statement on his identity fraudulently with the intention of misleading Edgar in order to induce him to enter into the contract. In fact, Edgar has a misconception or erroneous belief that the person at the showroom is Thomas Creek and entered into a contract with him. So when a misconception arises, there's a mistake in the contract. Moving on, it is important to identify whether this contract was made inter partes or inter absentes, as the court is more likely to render the contract voidable under fraudulent misrepresentation for the former and void for the latter. According to Citibank N.A. and Brown Shipley Company, face-to-face principle will apply when the contract was made between the claimant's agent since they have the authority to bind their employer into the contract. We can see that Edgar, a sales representative, has the characteristic of being an agent for Rosewood. Thus he can, and in fact he had bound Rosewood into the contract with Thomas Crook. Since it was Edgar who is entering the contract orally on behalf of Rosewood and he had dealt with Thomas Crook face-to-face, it would be treated as an inter partes case. In the case of Shogun Finance, there's a rebuttable presumption on inter partes case where the party intends to enter into contract with the person in front of him, and this is known as the face-to-face principle, which will not apply if there's a written contract. In order to rebut this presumption and have the contract to be void instead of voidable, the claimant must prove that it is an operative unilateral mistake where the identity is important. This presumption applies even when the buyer assumes a false name or practices any other deceit to induce the vendor to sell. To see whether a contract is void ab initio due to operative mistake as to identity, we again apply the 4 elements that were previously explained under Italian furniture. The first requirement is to establish Rosewood's intention to deal with the man. There's a distinction between where a person intended to contract with someone else and a mistake which is merely as to a person's attributes rather than as to their identity. A mistake as to a person's attributes, such as thinking that they are creditworthy when they are not, can leave the contract intact. As per Lord Denning in Lewis and Avery, when a mistake was made on attribute and not identity, the contract will not be void since it is not an operative mistake. Collective reading of facts of this case infer that Rosewood intends to deal with anyone in front of him who is creditworthy rather than only strictly intended to deal with Thomas Creek. This is because Edgar called David to assure that this person in front of him is dealable, and indeed, David assured him because he knew Thomas Creek is creditworthy. Also, similarly in Ingram and Little, Edgar Litton did not check on the identity of the person in front of him, therefore applying the same approach by Lord Devlin, which says that the identity is immaterial. Although in Ingram the contract is void instead of voidable, in Shogun Finance, the House of Lords confirmed that Ingram was wrongly decided. Thus, it should be voidable and not void, meaning that we should not follow the decision in Ingram, but merely use this case to conclude that it was a mistake as to attribute rather than identity here.
The first requirement is then not met since they intended to deal with anyone who is creditworthy rather than only with Thomas Creek. Next, the second requirement is to prove that the man was aware of the mistake. The requirement of proving the man who identifies himself as Thomas Creek was aware of the mistake must be proven by Rosewood in order to render their contract void for mistake and to recover their Korean furniture from Pine Furnitures. This requirement was hardly disputed because in the cases of mistake to identity, it is usually the result of a fraud being perpetrated on the mistaken party. It is clear that a dishonest party cannot represent themselves to enter into a contract with the knowledge that the other party would not enter into a contract with them. It can be argued that the man physically in the showroom was aware of Rosewood's intention to deal with Thomas Creek because he fraudulently uses the identification of Thomas Creek to deceive Rosewood and to let them believe they are contracting with the managing director, named Timber Creek, whose credit trustworthiness is attested by David. Nonetheless, this argument is not incontrovertible and to be accepted by the courts because Rosewood lacks compelling evidence to prove their suspicion.
The third requirement to have the contract void for mistake is to prove the mistake of identity is of crucial importance to the mistaken party. When parties contract inter partes, the presumption is that the party alleging mistake had intended to contract with the person in front of him regardless of his identity. This presumption can be rebutted only by very strong evidence, and oftentimes the presumption could not be rebutted, as was in the case of Phillips and Brooks Limited and Lewis and Everett. For a contract to be void from mistake to identity, the identity of the other party must be of fundamental and crucial importance to the party alleging the mistake at the time of negotiation, and the importance of the other party's identity must be made apparent from the conduct at the time of negotiations too. The reason why Edgar called David before accepting the check is to confirm the trustworthiness of the man who wants to buy the Korean furniture in the showroom. They did not regard the identity of the man in the showroom as of crucial importance because the importance of the identity of the man was not raised at the time of negotiations through any apparent conduct. Therefore, it cannot be said that Edgar representing Rosewood regards the identity of the person they are contracting with as a matter of crucial importance because the only thing they are concerned about is the trustworthiness and credibility of the buyer to make payment upon receiving the goods, not the identity of the buyer. Mistake merely about the creditworthiness of the rogue rather than as to his identity is not enough to have the contract void for mistake. In fact, it only renders the contract voidable under misrepresentation based on the case of Phillips and Brooks Limited. The fourth requirement is to prove the mistaken party has taken reasonable steps to verify the identity of the other party. Rosewood did not take reasonable steps to verify the identity of the rogue who identifies himself as Thomas Creek, and in the case of Phillips and Brooks Limited and Louise and Everett, it was held that the claimant's attempt to confirm the identity of the person they are contracting with must not be the ordinary attempt to verify the party's identity. That is to say, Rosewood must go beyond an ordinary inquiry to verify the identity of the man, such as at least requiring the man to provide some sort of solid proof, for example his identification card or driving license to verify his identity. Merely calling David to verify the identity of the man in the showroom who identifies himself as Thomas Creek does not reach the threshold of reasonableness, therefore Rosewood cannot be deemed as taking reasonable steps to verify the identity of the person they are contracting with. Our conclusion for Korean furniture is that there is no operative unilateral mistake as to identity because none of the requirements to have the contract void for mistake as to identity are met, and the presumption on inter partes is not rebutted on the ground that Rosewood is concerned about the attribute instead of the identity of the man in the showroom. The contract between Rosewood and the man is valid. Rosewood cannot recover the Korean furniture from Pine Furniture under Malaysian law and English law because Pine Furniture has a good title over the Korean furniture. Rosewood can only rescind the contract with the rogue and claim for damages. Our overall conclusion for this assignment question is Rosewood cannot recover both Italian furniture and Korean furniture from Pine Furnitures because the requirements to have the contract void for mistake as to identity are not met under English law. Their contract will be valid but voidable for misrepresentation. Rosewood can rescind the contract with the rogue, but they cannot recover the furniture because the good title of the furniture has already been passed on to Pine Furniture who acted in good faith. Rosewood can only rescind the contract and claim for damages, and since Malaysian law in this question follows the common law, the approaches will be the same as what we have established under English law.